Hello, my name is Tim McCurdy, and I am a guardianship lawyer practicing in St. Louis, Missouri. Today we're going to be talking about defining incapacity for adult guardianship in Missouri. In Missouri, guardianship will only be entered for an individual who is found to be incapacitated. When you are considering whether guardianship is appropriate for your circumstances, you should keep in mind that in the legal system in the United States, we really put a value on individual rights and personal liberties, such that an individual should be able to make his or her own decisions, even when, frankly, those might not be great decisions. But the court will not come in and stop someone from making what we may consider to be a bad decision. Instead, the courts will only appoint a guardian, which is the court saying that someone lacks the ability to make decisions for him or herself, so much so that someone else is going to do it. They're only going to do that after a hearing when the court is satisfied that the individual is incapacitated. So what does that mean in Missouri? What does it mean to be incapacitated such that a guardian will be appointed? In Missouri, we have a legal definition for guardianship and incapacity, whereas the guardianship will be appointed when someone meets a definition created by the statutes in terms of whether you're incapacitated. And it's this big, long definition of incapacity, and we're going to break that down a little bit so that if you are considering guardianship for a loved one, if you're in a guardianship proceeding, you have an understanding of kind of what we're talking about. So first, incapacitated person is one who is unable due to physical, mental, or cognitive condition. So they have some form of impairment, either physically, that they're not able to do things, or mentally, which will most often refer to some form of psychiatric diagnosis, or a cognitive condition, for example, dementia or Alzheimer's, where based on their inability of physical, mental, or cognitive condition, that person cannot or is unable to receive and evaluate information or to communicate decisions. So that would be one where, for example, they have a cognitive impairment, they have dementia, such that they can't, if they were talking to a doctor and trying to decide whether they needed medical treatment, they wouldn't be able to understand the information that the doctor was telling them and make a decision, evaluate that information, make a decision, and communicate that to the physician. Even with appropriate services and assistive technology, so that there isn't some device or there isn't some service that we can provide to the person that will help them overcome that impairment. And I think that's an example to show how hesitant the court would be to enter a guardianship, because they want to make sure this is truly kind of a last resort type of thing. So they are unable due to physical, mental, or cognitive condition to receive and evaluate information or to communicate decisions, such that the person lacks the capacity to manage the person's essential requirements of food, clothing, shelter, safety, or other care. We often refer to this as someone is unable to manage their own affairs. And it's broken down in the statute in these different categories where, for example, the person can't decide where to live, or they require too much help that they wouldn't be able to live independently, or it's unsafe, that there's just it's a hazard if a person's going to live alone, or with food, they're not able to take care of themselves, they're not able to manage these things due to their incapacity. Such that, so it's, the person is unable due to their physical, mental, or cognitive condition to receive and evaluate information and communicate decisions, and they lack the capacity to take care of their food, their shelter, or protect their own safety, such that serious physical injury, illness, or disease is likely to occur. So again, just emphasizing that the standard is rather high for guardianship, to say that it's not just that someone is making bad decisions, it's not just that, it would be better, we think, if they, lived somewhere else or did something else. The standard is that their lack of capacity is such that serious physical injury, illness, or disease is likely to occur. So this is what you have to show at a guardianship hearing to be successful. And understand that the definition of incapacitated person includes a partially incapacitated person. So that can fall into numerous different scenarios where you say that someone, they may be able to handle some parts of their life in terms of making decisions or doing certain things, but it's not safe for them to live alone. So they're partially incapacitated. So we need to be able to have someone who can say this is where you're going to live, but that person is still going to have a voice in other decisions that they are able to make and communicate. I hope you found this information helpful regarding the definition of incapacity for an adult guardianship in Missouri. Please keep in mind that the video is provided for general information only, and if you have any specific questions, understanding that everyone's situation is unique, and if you are preparing for guardianship or involved in guardianship, you really need to speak with an attorney, please feel free to contact me. I'd be happy to talk to you and with you about your circumstances. Thank you.